clear that Texas's allied litigant doctrine only applies to communications to a lawyer representing another party to the action. The leading Texas Supreme Court case on this, In re XL Specialty Insurance Company, also makes this clear at page 52, saying that in page 54, excuse me, that in a case where communications were not made to the insurance lawyer and the insured is not a party to the pending action as required by the rule, the allied litigant privilege does not apply. Plaintiffs in their opposition raised the issue of whether there's a subpoena party exception, and it's clearly not supported by either the text of the rule itself or the case law. And if I could have permission to share my screen, Your Honor, I have a case that I think is directly on point for this matter.
Okay, go ahead.
Let's see if I see the. All right, and is that sized appropriately, or should I blow it up more, Your Honor?
No, this isn't too bad. That's a little better.
Okay, I can enlarge it. So particularly here, on the subnumerate 2 at the bottom right hand corner of page 4, the highlighted text clearly says that the allied litigant doctrine only protects the disclosure of documents between parties to the same active litigation. And at a hearing in this case, a non-party LifeSpace argued that it is a party to the litigation because it is a subpoena party. After the court went on to discuss the allied litigant doctrine and In re XL Specialty Insurance, they addressed this at the *6 page. And they say that as it regards Texas Rule of Evidence 503, the term party has been interpreted narrowly to mean only persons who are co-litigants, either co-plaintiffs or co-defendants in the same pending action, not in separate cases. And they go on to distinguish the federal common law, a common interest privilege, which is wider than the privilege recognized in Texas. And the court says that therefore, under Texas law, one must be an actual co-litigant in pending litigation for a communication to fall under the allied litigant exception to waiver of attorney-client privilege. So I think this is really an open and shut issue here. Mr. Barnett and Mr. Huddleston are not parties to the litigation, so there cannot be any allied litigant privilege or allied litigant doctrine here. So we'd like the court to order plaintiffs to produce all responsive communications being withheld under this allied litigant doctrine within the next 7 days. And I don't know if Your Honor wants me to go through all of my arguments or to let the parties go back and forth. But
yes, Judge, if I may, if I could ask first for Mr. Sindelar to give us the site for that and tell us what court cited it, because I haven't ever seen that case before.
Certainly, that is In re Northwest Senior Housing Corporation. It's a case from April of 2024 out of the Northern District of Texas, Dallas Division. And in case there's any, the site is 2024 Westlaw 1810792. And that is a case where they are applying the Texas privilege law, not the federal laws under Federal Rule Evidence 501.
Thanks so much. So, Judge, I would start out by saying I haven't seen this case before, but I'll tell you that it's the bankruptcy court for the Northern District, so I know it's not binding. The situation that we've got here, I think that Mr. Sindelar simplified it a bit, and my response attaches a lot of documents, but the defendants in this case have filed a 90 some odd page counterclaim that's replete with allegations against my client, and then also John Barnett and Billy Huddleston, the individuals who are at issue here. The defendants refer to them throughout the complaint as Mr. Tubulay's quote unquote associates. If you look and read, they accuse them throughout of wrongdoing. They're alleging that these two individuals have taken millions of dollars that they believe belong to the defendants. They have, in connection with that, they've served a number of subpoenas on the defendants and their related entities. Those documents, Judge, are attached as Exhibit 17 to 25 of my response. And if you look at it, they're asking not only for transactions that are at issue in this litigation, but they're asking for communications between Mr. Huddleston and his various related entities. In addition, currently with Mr. Huddleston, he has filed a motion to quash a subpoena that was served on his bank and also a deposition notice. And the defendants, as well as Mr. Huddleston's attorneys, have talked about the intent to sue by the defendants, the intent to sue Mr. Huddleston. So if you take a look at, sorry, Judge, if you look at page 1 of Mr. Huddleston's motion to quash the subpoena and deposition notice and for protective order that was filed on April 5th of 2024, Mr. Huddleston notes that the defendants are attempting to improperly utilize the subpoena mechanism to gain information from a party it intends to sue in this matter. The Huddleston motion also points out that the defendants have indicated a possible intent to sue him. Then, if you go through and take a look at the defendant's motion that they filed in response to Mr. Huddleston's motion on May 22nd, 2024, it's on page 4, and they say, or they allege that Tubelay diverted and misappropriated tens of millions of dollars from defendants by concealing self-dealing transactions and employing a host full of unlawful schemes, including inserting himself, Sinistar, Jamalabox, and other associated people and entities, including Billy Huddleston and Huddleston's company, BDHL, as middlemen in transactions involving defendants and third parties to unlawfully profit from the transactions at defendants' expense. So, Judge, they're saying here out of one corner of their mouth, hey, these guys aren't parties, it doesn't apply. But at the same time, they're indicating their intent to sue these entities to their lawyers. In addition, in connection with that motion that was filed by defendants, they're seeking attorney's fees from Mr. Huddleston. Mr. Huddleston and Mr. Barnett have both been forced to get counsel to represent them in connection with these subpoenas. The In Re XL case that was discussed by Mr. Sindelar involves a workers' comp administrative proceeding where the lawyer in the subsequent lawsuit was communicating with the plaintiff, the workers' comp insured, about what happened in the underlying workers' comp administrative proceeding. That's not the case here, Judge. The communications at issue are between the plaintiff's lawyers, Mr. Huddleston's lawyers, and Mr. Barnett's lawyers regarding matters of common interest, which are the subpoenas that have been served on him and the allegations that have been jointly made against our clients. If you take a look at text rule of evidence 503 B1C, I think this falls squarely within the definition. What Mr. Sindelar is indicating is that basically because they haven't sued Mr. Huddleston yet, that this privilege doesn't apply. And I don't think that's the case, Your Honor.
Response?
Yeah, the Texas rule is very clear on this, that you have to be actual parties to the litigation in order for the allied litigant doctrine to apply. What plaintiffs are asserting here is the common interest doctrine, which is the doctrine adopted by federal courts and that Texas has expressly rejected. So this is a
Bowen,
known.
do you have any cases where the common interest doctrine has been adopted in Texas?
I don't, Judge, and I'll tell you, honestly, I believe that the NRA XL case says that it's not the common interest doctrine that applies. And I would tell you that respectfully, I don't believe that's what I'm asserting. They are, right? The rule says the privilege applies to communications by a client's lawyer to a lawyer representing another party in a pending action. And I think it's very narrow. Like I said, the defendants are seeking attorney's fees from Mr. Huddleston. To say that he's not a party when he has gotten counsel and is involved in this case. And importantly, the defendants are saying that they want to sue him. It's throughout Mr. Huddleston's motion. So the idea that somehow because they're not a quote unquote party at this time, I think misses the point.
Okay, I'm not sure I'm 100% following you, but so you don't have any cases that apply, because the case law that provided by Mr. Sindelar clearly says that you have to be a party to be able to assert the allied litigant privilege, and it distinguishes the common interest privilege, which apparently has been adopted in federal court. In this case, the party we're talking about is just a subpoena party. They haven't been brought in. This case seems to be kind of on point. Is there any contrary authority?
I'm not sure of it, Judge, and I'll tell you, I wasn't able to find a controlling case in the state of Texas that deals with that.
Okay. All righty. So, Mr. Sindelar, so I agree that the allied litigant privilege would not. So, to the extent there's any objections made to discovery under the allied litigant privilege to subpoena parties only, I will overrule those objections. You said that was one of the four things that you wanted to bring up.
Yeah, that's right. Thank you, Your Honor. If I can move on then to text message redactions, that's the next issue we have here. So this is kind of creeped up. I think this is the third or fourth time we've been before the court about the text message communications Mr. Tublay's had with others. And the issue now is that after the most recent supplementation, plaintiffs I think I counted 84 text message conversations. 50 of them contain redactions, including 14 where the conversations are redacted in their entirety, which calls into question why they were produced at all if they're supposedly not responsive or relevant to the case. And what I wanted to do is address the case law that's on point in this, which is very clear that responsiveness is not a reason to redact a document that you're producing. And if I can share my screen again, Your Honor, I can point to a couple of cases on point addressing this matter as well.
Okay.
So I want to start with the Pavilion Bank case, which let me widen the view of that again. So this is a case, again, out of the Northern District of Texas, and they address unilateral redaction. The court says, as an initial matter, the court considers plaintiff's unilateral decision to redact from board meeting minutes what it purports is non-responsive information. And the court looks at other district court decisions, including the Sims case, which is a Western District of Texas case that was published in the Federal Rules Decision Reporter as being particularly instructive on civil procedure. And that case notes that redaction is an alteration of evidence, and a party should not take it upon him, her, or itself to decide unilaterally what context is necessary for the non-redacted part disclosed and what might be useless to the case. And it cites a number of cases to this effect, concluding that the court finds the rationale set forth in these opinions to be persuasive and well-reasoned. Thus, the undersigned concludes that plaintiff was not entitled to unilaterally redact information it believed to be irrelevant or non-responsive. Further, any concerns regarding proprietary information and confidentiality are sufficiently addressed by the agreed protective order entered in this suit. And as Your Honor is aware, we have an agreed protective order in this suit that addresses any confidentiality or privacy concerns that a party may have. Another case on this point is McKinney-Pearl, which is a case out of the Northern District of Texas. Again, another case selected for reporting as a federal rules decision case. And this case also addresses unilateral redactions by a party. And the court notes that as discussed with counsel at oral argument, defendants cannot properly redact non-privileged information from any responsive document. And then the court wants the parties to meet and confer about adding a higher level attorney size only designation to the protective order. And that once the modified confidentiality order is entered, defendants must produce any documents previously produced with redactions based on any confidentiality or non-privilege based reasons within 7 days of the order. And just to give your honor a flavor of the type of things that we've seen redacted here, I'm gonna show these are messages with Mr. Logan Wheat, who was involved with Blackhorn, and Mr. Tubley. And on 4/20/23, Mr. Tubley says, thanks for the visit and conversations. Skip 11 money was sent. And he asks a question, any news on the minerals contract / draft? And we have a redaction. We don't know if that's a response to his question or not. Mr. Tubley again says, Logan, Boris likes the Penn sand and other sand at circa 1,700 feet. Did we drill skip 1 first and now move to skip 10? Have we received the recorded assignments of the last 2 mineral purchases yet? Again, we have a redaction. Then Mr. Tuble asks, has any Blackhorn well been plugged out of the Kentucky wells? We have a redaction. Logan, just wondering when we can expect revenues from the Hunt wells. We have another redaction. Then Mr. Logan asks if Ms. Bowline from Mr. Lawton's office can call and discuss something with Logan. Logan says, no worries, that shouldn't be a problem. We have more redactions. Another question about a well, and then we just have more redactions, Your Honor. So the case law is clear that a party cannot unilaterally redact based on non-responsiveness. And the problem, as you see here in these messages, and I can give you more if you wish, Your Honor, but I know we have a limited amount of time here. You know, we're left to guess whether or not these are relevant or responsive or not. And a party is not allowed to do that. When you produce documents in litigation, you produce the entire document to provide the necessary context, and it's up to the parties to determine how to use that information in the context of the full document.
Okay, response?
Sure, Judge. I understand the case law that Mr. Sindelar cited is very interesting. I agree. But the issue with what's been redacted here is information that's not responsive and that it's not a unilateral redaction. Judge, if I can I share my screen? I want to show the judge the April 30th, 2024 order where the court orders the plaintiffs to produce text messages that relate to the transactions at issue in the lawsuit. Let's see.
I guess one question I have just looking at those text messages, so you didn't redact the questions, but you did redact the answers? That seems a little strange.
Sure. So, Judge, I can't tell you right now exactly what those are. I will tell you that we went through those carefully. Anything that's related, and I think you'll agree, or I don't know, Mr. Sindelar, I think you'll agree, we were overly inclusive. We didn't just include stuff that was for the transactions that actually went on. We included everything where Mr. Tuble was talking about his role, what he did. So here, Judge, is the order where important part, it says we should produce to defendants text messages in native format or in a reasonably usable format within their possession, custody, or control that relate to the transactions at issue in this lawsuit during the relevant time period. Judge, that's the same language that we've used on the bank statements in this case, which, if Your Honor remembers, we were permitted to redact things that weren't related to the transactions at issue in the lawsuit prior to production of those documents. This is something.
So I don't have a problem with you redacting it necessarily, because there may be certain text messages that are just, can you pick up, potatoes from Tom Thumb? That wouldn't be relevant to this case. The thing that's unusual about those particular ones is you seem to allow the questions and not the answers. And I don't know how the questions could be relevant, but not the answers. If that makes sense. I just still don't understand that.
I would agree with you, Judge, and I'm happy to go back and take a look at it. It's my belief, from looking at it that way, we wouldn't have redacted if it was a response to that answer. My belief is that those were for something else. But again, I didn't have this to look at prior to the hearing today. I'll be happy to look at those and update you.
Okay. So I guess what exactly do you want me to rule on at this point, counsel, Mr. Sindelar?
So what I would like Your Honor to rule on is that you look at the text message conversations as a whole, not as individual messages, and that the default rule and what the legal authority says is that you produce the entirety of the document, and you only redact if there's something that's privileged or if there's a personal identifier like a social security number or a bank statement. A party doesn't get to pick and choose to redact things based on relevance or responsiveness. That's what the rule is.
That federal case that you cited to, I've never handled it the way you're talking about. If you don't seem to have any state authority, I think it's fine to redact documents and turn them over, especially in a situation like this where you've had a court order that says you need to produce those. I do admit that this seems very strange that all the questions were produced and not the answers. And so, Ms. Bowline, I would strongly urge you to really double check that if those are occurring, that you're not cherry picking what you're putting in there, because that is the kind of thing that could lead you to sanctions.
Absolutely, Judge. I'll be happy to take a look at that conversation and get back to them.
And if I may further on that, Your Honor, there are 84 text message conversations. Some of them are hundreds of pages with extensive redactions, and I don't want to have to ask Your Honor to review them in camera to determine what's responsive or not. But I don't think it's fair for defendants to be in a situation to just have to take plaintiffs at their word on what they're redacting or not. And I'd note that Texas, the INRI Weekly Homes case recognizes that where the Texas discovery rules are not inconsistent with federal rules or case law interpreting them, Texas looks to the federal courts for guidance. And part of the issue with redaction is that when you redact the document, you're not producing.
Counsel, I understand the issue with redaction. I've dealt with this a long time. So let's move on to your next point.
Judge, can I just make one point, please?
Okay.
I want to just underscore one big point here. The employment contract at issue, the subject of this lawsuit that was negotiated between my client and the defendants, has language in it that every claim that could be brought against my client is contractually waived and subject to indemnity. Okay. That was part of the negotiation. A lower price was reached. And so the point is this: is we've been defending a 90-page counterclaim on claims that are contractually. Just completely turn your volume off. 1 second, Judge.
Mr. Lawton, that may be perfect grounds for a summary judgment motion, but we're dealing with discovery at this point. And so,
well, that goes to my point, which is the court has to also consider the breadth of discovery and the demands for the case.
okay. I mean, I've already made a ruling on what needed to be produced, and it was about the transactions and issue. I'm not reversing myself on that, so I'm not.
I'm not asking you to. I'm just making the point that this discovery in general, it's gotten awfully unwieldy given the demands of the case. That's just a broader, big picture point. I'm not asking you to reconsider any ruling.
Okay. All right, we only have 2 more minutes. So what else do you have, Mr. Simula?
All right, so 2 issues. I guess the one I was going to take last is involving the laptop that Mr. Tuble has, where data was destroyed, and we're gonna move separately to see about getting a special master forensic expert to look at that to determine what happened with that. The last issue is with regard to the metadata here, and a party has an option under Rule 196.3C to either produce documents as they're maintained in the usual course or to label and categorize them by RFP number. Here, plaintiffs have done neither. For ESI, you have to produce the ESI with metadata, which is the same as how plaintiffs wanted us to categorize and label hard copy documents, which we did for them to comply with the rules. Here, that they've supplemented to provide file names, but with their supplement, they've only provided the file paths for a single document that they've produced. The rest of them they've claimed privilege, but that cannot be the case because we want the file name to show. Just as a file cabinet has files and folders, we want to know how Mr. Tuble had the files organized on the hard drive of his computer, and they've claimed that information is privileged, which it categorically could not be. The native file path of how he maintained his files is metadata that is necessary for the production in the ordinary course. I could show Your Honor a case on that point as well, if you would like, but the issue here is that the plaintiff should be forced to comply with Rule 196.3C, and that means that they either have to provide the file paths for the ESI so that it's produced in the usual course, and the last save by date, which I think we have a disagreement over whether they produce that or not. And if they're not going to produce the documents as they're maintained in the usual course of business, they have to categorize and label them. They have to do one or the other. They can't do neither.
Response?
So, Judge. Sorry, just 1 second. So first of all, we've got a disagreement about what we've produced. Your Honor, we've produced all of the non-privileged metadata. This idea that somehow they're not able to tell where the documents come from is false. And if I can show, Your Honor, really quick, that their complaint now, because we've given them the file names for everything, their complaint now is that they don't have access to the folder and the path, and that somehow this would provide them with additional information. If I can show my screen, Your Honor.
Okay.
Your Honor, this is a page from defendant's production. And if you can see here, I apologize, Judge, I'm shrinking it down so that I can see this. So these properties that they're saying will give them additional information that would somehow be useful to them in assessing the document. If you look at yours, this shows that there's an unspecified custodian for this, which is the case for 23,000 plus of the defendant's documents. If you look down here, it shows the folder. Judge, you see this? It says 2024-210, and it's a Bates range of the documents that were produced in that production. Then you look down here and it says file name, Wolfpack Coding overview.doc. Down here, the path, this is the folder that, or the what Mr. Sindelar is saying that they need to be able to assess our production. If you'll take a look and see there, it's just the name of the file. There's nothing there that would allow you to assess in any way the way that this document was maintained. Having said that, Judge, I will tell you that the way that Disco works, that's the e-discovery tool that we're using. The way that it works, you have to upload it in a folder into the system. And so I'll tell you, Judge, I created those file names. Those are my core work product. But having said that, there's nothing in there that would assess or assist them in learning the manner in which these documents were maintained. And further, one more thing about the ordinary course of business. I think I already said these were maintained in the ordinary course of business. But if you look at the Heartland food products case, Judge, that was cited by defendants, it talks about how you determine whether or not emails were produced in the ordinary course of business. And it says, I'm going to read the quote, emails are produced as kept in the ordinary course if they provide sufficient information about the email, including custodian, attachments, and date and time sent or received. And Judge, I don't think that the defendants will dispute that they've got all that information.
All right, response.
Yeah. So what we're asking for is what the rules are, what the rules require. I don't know about the isolated document they picked up, but if I could share my screen again, I'd like to show another case dealing not with emails but with files saved on a hard drive. And the problem we have here is we don't know how Mr. Tubley organized his files, which would allow us to look through the documents in a systematic manner to help see how we organized, how we sorted things, and help us get a general sense of the documents in the context in which they were maintained.
Guys, I'm so sorry. I have an emergency hearing, I believe. Mr. West, are you there? All right, stop sharing, please.
Oh, sorry.
Mr. West, we have an emergency hearing. Mr. West, are you there?
Yes, Your Honor. Craig Capua, Royce West are here.
All right. And opposing counsel, are you there?
Yes, Your Honor. Allison Stewart for the Garnishy Chase.
Okay. You're not the same attorney that was here before.
I'm not. I'm actually here with Truman Spring in his office, actually. I filed a notice of appearance today, though.
Okay. Are you Texas counsel or?
Yes, Your Honor. I'm at Greenberg Traurig in Dallas.
Okay. All right. So this is a case, Mr. Hurst, that you worked on extensively.
I recognized it. I recognize Mr. Capua, but
Yeah. I guess are you not representing Google anymore, I guess, or?
I think hopefully Craig will agree that Google's involvement in this matter is no longer, but I still get the orders and I'm still on the list. So I did see that. Good to see you, Craig.
Hey, hello, Michael. Yeah, we don't need you on this one. Thank you.
All right. So I'm a little confused what's going on here on this case because, and I'm sorry, Tony, can we go on the record on this one?
Yes, Judge.
Come on the record on DC 223943 Moss v. Google LLC. Counsel, make your appearance.
Your Honor, good afternoon. This is